Alright everyone, today on Cautionary Tale for people about actually reading news articles before you comment on them. Liberals celebrating this, they wouldn't if they had actually read the article from the AP or any of the others. Link in the description, archived of course. And people who are like myself, very pro-gun, a lot of them are saying, oh, what a dark day for democracy. The Supreme Court is being derelict and throwing Maryland gun owners under the bus by not considering the assault weapons ban there. Yes, they actually went so far as to ban most modern weapons entirely in that state. In the end, it'll be torn apart legally. It's not going to stand, don't worry. Whether that involves the Supreme Court or a lower court remains to be seen. And that's what the Supreme Court did. There are still considerations at the appeals level in this particular case. SCOTUS generally doesn't leapfrog lower courts and begin making its own decision when it can just sit back and see what the decision is at the lower court level. If in the state of Maryland it's already thrown out, and it probably will be, they don't need to consider the case and create a federal level precedent. It can remain in that state. They do this with the federal court system and with state supreme courts all the time. They wait. Unless it's a major pressing issue, like the Bruen decision, obviously, things had begun to come to a head. They had no choice but to weigh in there. But that was after all the lower courts had already gone through the proceedings over the course of several years. Then they made their decision. The Supreme Court is reluctant to leapfrog and to show its ass to the lower courts, out of a sense of judicial decorum, number one, out of the fact that they don't want to have to take up 10 million cases every year, number two, they like to keep the docket streamlined generally, and number three, because it can create social alienation. Like, for example, many years ago, you remember in the lead up to the decision on whether gay marriage was going to be countenanced nationwide. The Supreme Court very wisely, it hampered people at the time. I'm in favor, by the way, of gay people being able to marry. I don't care. But waiting made more sense. You had the public was still very much 50-50 until a few years before that decision in the end was made. It was impossible to forever maintain a patchwork throughout the United States, and they tried to ease things over by saying, okay, there's going to be reciprocal marriage licensing. The state doesn't have to marry the gay couple, but if they get married somewhere else, it's still going to be legally binding. That smoothed things over some. SCOTUS waited until it was clear that the majority of the population wanted it to be legal and that it was moving steadily further in that direction. They said, okay, at this point, the social alienation that we do cause by making such a binding decision is far less than it would have been 10 years ago, and so now is the time to do it. And of course, it became the law of the land, and gay people can get married. Satan did not jump up out of a hole in the ground, although there are definitely some devilish people out there with proclivities that are far beyond simply wanting adult consummated relations. Some of them are getting really creepy at this point, and I know you probably understand what I'm talking about. No, I do not think that third graders need to be read an explicit book about sphincterbation by a person in drag. I'm just saying that that would be considered inappropriate no matter who was reading the book, right? It's not really necessary. It's also not part of an actual education. It makes no sense at all. SCOTUS is not being derelict on your gun rights. They're waiting to see what the lower court does. And it's right in the article. David Hogg weighing in. He linked out the article. And he simply responded, good. Well, he didn't read the article, now did he? The case is still very much open. It's just that SCOTUS isn't deciding to leapfrog the appeals court, which is good. They're not supposed to do that. If the lower court is capable of, if the lower court finds in accordance with Bruen, which they supposedly have to consider for the purposes of a case like the Maryland assault weapons ban, then they're going to shoot it down, pun intended, because there's no way they can possibly comport it to Bruen. There is no historical precedent for pretty much any gun control in the United States prior to the Cruikshank decision. All of the founders and Revolutionary War soldiers were long dead by the 1870s. You know, the average lifespan back then wasn't actually 100 years. I'm just saying. It was probably a couple of people that enlisted when they were 12 may have still been kicking around then. They were probably against the Cruikshank decision too. And it's been countermanded by separate Supreme Court cases. It's been countermanded by Heller versus D.C. and by McDonald v. Chicago anyway, so you didn't even need the Bruen decision to nullify that bullshit. Fact is, we're moving generally in a good direction in the country. And that's because of the obvious civic precedent of having a well-armed civilian militia. That's the whole point. The Second Amendment is 2 sentences long. It doesn't take any interpretation. It's very explicit. As long as you understand the parlance used in the late 1700s, you know exactly what it says. People just decided that regulation should generally be a government and bureaucratic term as opposed to the original very mechanical term that it was generally understood in at the time. Read the headline and you'd think, oh my God, Maryland's going to keep those guns banned, and the Supreme Court, how dare the Trump justices not want to take up the case? They will. If the Maryland court system finds that it's constitutional, they'll countermand it and cite Bruin, and they'll probably expedite the case. It'll just take a while. Again, this is a blue state, so you don't want to make a decision at the federal level that you don't have to because a state-level decision can already be issued by the lower court. It's not dereliction. This is proper etiquette. This is proper decorum for a judiciary body. So I read it when I first got fronted by, I think, 3 or 4 different people sent it to me. And they're like, oh, did you see this bullshit? And then I read through the article. I'm like, oh, it's not bullshit. It's concerning if you read the title of the article and the tagline on Twitter or something like that. Once you actually go a couple paragraphs in, you find that their reasoning is quite kosher, actually, that their reasoning stands. Supreme Court, 99% of the time, does things like this. It keeps it at the lower court level to be considered. Then eventually, if it has to, it weighs in. But and this is a more activist court than we've seen in a generation. This court is much less reluctant than the Bush inception or the Obama inception of the Supreme Court to take up cases. And that's partially because of the 3 Trump justices. They have been much more activistic than other incarnations of the court have been in quite some time. Since, God, at least the 70s or thereabouts. Even then, probably more reluctant. I mean, look at Bruin is a good example. Bruin, Roe v. Wade being considered, the Dobbs decision, that was a huge move, a power play by the court. You've got the upcoming Chevron case. They're still going to be doing that. Chevron will be a big one. My hope is that they side with sanity and cut down the bureaucracy to size in so doing, by the way. That would be a huge win. I just wish that they could... go after Citizens United or something, reconsider that case and say, no, contrary to Mitt Romney's belief, corporations aren't fundamentally people. No, they're not individuals. They're not life forms. They're comprised of people and also inanimate objects and shit like that. Again, it's pretty fucking obvious. Sometimes the court doesn't take up the obviously correct position. All you have to do is have a rudimentary understanding of civics, but sometimes they punt. And there are cases when the Supreme Court really should take up something in an expedited manner, and then it takes them a decade. Or something, technically speaking, there's such an obvious right and wrong decision to be made, like with gay marriage. It never made sense that the government can deprive people of what is effectively a proprietarian contract. It's not the same as a religious marriage ceremony. But they waited. Now, the pragmatist in me applauds them for waiting and said, okay, you would have caused a lot of problems if you'd waited in 15 years earlier. But it was so grossly unconstitutional as well. Same is true with guns. That's the one thing I wish that they would be more speedy on. But they can't be so speedy that they begin countermanding lower courts before they're able to make a decision, cite their case law, lay out exactly what their arguments are, because then the pro-gun justices have something to actually nail. They have something to actually debate against and issue their rebuttal and tie up all the loose ends and make it nice and legalese. They can't do that if there's no lower decision to actually countermand. And I have a feeling that they will countermand it if it's upheld at the lower level, because it's so obviously and disgracefully opposite their own pre-existing decision with Bruin. That's about all. Peace out.